Welcome guys. This is going to be the final video for the Sanctions summary series. So what we're going to have a look in this video is pretty much the final 5 key knowledge areas that you will need to know. So it might be a little bit longer this video just to get through these 5 areas, but we'll take it away from the top. The first one we're going to look at is the purposes of sanctions. So what we mean by this first point here is what are we trying to achieve when we hand down a sanction, such as imprisonment, such as fines, for example. So it's important that we need to consider these 5 things, or any judge or magistrate is going to consider these 5 things before they hand down someone's punishment. So first of all, when we look at handing down a punishment, usually it would be to punish someone. So we need to punish someone on behalf of the victims and their families. So if it's been a serious crime, like a murder, for example, we need to provide some kind of justice. Especially for the offender, we need to punish the offender for the harm that they have caused. So we need to show people that they can't just get away with crime. They need some sort of consequence as a result. And lastly, we need to understand that in Australia, we don't have the death penalty or anything like that. So the harshest punishment we do have in Australia is imprisonment. It's kind of seen as the ultimate form or the last resort available. Next one we have is to protect. So generally, this is more so relevant for imprisonment. So when we are achieving protection, we want to protect our community from further reoffending. So we don't want the dangerous offenders to be in our community, to be at risk of causing more harm. And what it does by imprisoning people is that we remove people who are a danger to society. So if we think they're an unacceptable risk, we'll remove them from the community for a set period of time to stop them from committing crimes. But we also have other types of things that protect us and our community, like if someone's caught speeding or driving under the influence, for example, that we can suspend their license, for example. So sanctions generally and protection kind of more so relevant for imprisonment. Next one we have is we are often trying to achieve deterrence. So when you think of deterrence, I want you to think about trying to stop someone from doing the same or similar crimes in the future. So ideally, we do this through 2 main ways. We have general deterrence. So what that means is we see their outcomes handed down to other people. So say, for example, in the news, we see someone handed down 25 years of jail time. Ideally, we see that and we don't want to commit similar crimes because we know how serious the outcome is. Or another example might be we achieve specific deterrence. So in the past, if you have received a punishment or you receive a punishment, you ideally don't want to receive that same punishment again. So you're not going to commit that crime yourself. You're specifically deterred. So an example of that happened in my life is that I got a fine for putting my feet on the seat for $180. So specifically for me, I'll never do that same offense again because I know the consequences again. But in terms of general deterrence, because I've told you guys about it, it generally will discourage other people from doing the similar crime because they know they'll get that fine if they put their feet on the seat as well. Next one we're going to look at is what's known as to denunciate. So when you hand down a denunciation, I guess, it's when you're giving someone a harsher than necessary sentence. So the way I think about this is, let's just say there has been a massive increase in youth crime in your community and it just keeps happening and there's been no changes at all. What the judge might do is they might give someone a much harsher than normal sentence to kind of show the community that they want to stamp out that behavior. They don't find it acceptable and they want to really show disapproval. So hopefully, because the crime has been increasing so much, or youth crime, they see people starting to get really harsh sentences. They might encourage future people to rethink going down that same path. Lastly, we have to rehabilitate. So when we are achieving rehabilitation, we want people to basically change their ways and become law-abiding citizens. So whether that's through specific programs within the prison or community corrections order, ideally, when we hand someone down a punishment, we really want them to learn from their mistakes and hopefully not do that same crime ever again. So that's a really good overview about we're looking why we have sanctions and what we're trying to achieve. Now we're going to look at what the judge will consider when they're actually going to hand down the punishment, or what's known as the sanction. So just for starters, I want to keep refreshing your mind on this statistic that a lot of people return back to prison within the first 2 years of leaving prison. So the judge really does need to consider that when handing, say for example, imprisonment down, because it could lead to a really serious ongoing cycle of reoffending. So first of all, when we look at the nature and gravity of the offence, so the judge is going to see the case before them and they need to take into account the seriousness of the crime. So generally speaking, for example, if a crime has been planned out for months in advance, it's very premeditated, someone like that is going to get a much harsher punishment than someone who's just committed a crime in the spur of the moment or in the heat of the moment type thing. So they want to basically assess the degree of criminality. So how responsible was this person for the crime, and how serious was the crime? Did they plan it? Was it spur of the moment, etc.? Second thing a judge or magistrate is going to consider is whether a person pleads guilty early. So what I want you to think of with this one here is basically, if you get charged with a crime and you have done the crime, the sooner you plead guilty, the better the outcome is going to be for you. If you decide to plead guilty all the way towards the end of the trial, you're not going to get as much of a sentence discount compared to someone who pleads guilty before it even goes to trial. And the reason for that is our courts are very backlogged. There's a lot of cases waiting to be heard, so it saves a lot of time and money for the courts. But also on a more like personal note, for the victim, it saves them having to go to court and confronting the accused person. So hopefully it reduces a lot of trauma as well. So that's a really, really important one. Next one, this one is something you'll see in year 12 legal studies a lot, what's known as a mitigating factor. A mitigating factor, a really good word to use is that it decreases the culpability of an offender, or decreases how responsible they are for the crime, I guess, or like takes away from their sentence. And generally some things like if you're a first-time offender, you're very young, you cooperate a lot with the prosecution or the police during their investigation, it's going to lead to you getting a lower sentence overall. Flipping over to our next couple, we have an aggravating factor. This is the complete opposite of mitigating, so it's where it increases the culpability of the offender and means that you get an increase in your sentence. So some really common ones are if you premeditated, or that essentially means you planned out your crime. If you have an extensive criminal record, you're generally going to get a harsher sentence than someone who has the first offense. And generally, a lot of really common ones that happen as well in today's day and age is people committing crimes while on bail. And also the use of a weapon such as knives are very common right now, and a reason why people get increased sentences. Alright, the last one we're going to look at here is previous offending or lack of offending. It's kind of tied into the ones we've chatted about before, but basically it's pretty straightforward. But if you have a really high or extensive criminal history, you're going to get a much harsher punishment than someone that has no criminal history. So generally what we're looking at, when you look at these guidelines for sentencing, you basically need to be able to tell the person marking your assessment task is that what might the judge have considered when they were handing down the fine, or what might they have considered when they were handing down imprisonment, and you're linking to these kind of 5 guidelines here. All right, moving on over. For this SAC, you just need to know in detail the kind of the definitions of the 3 main sanctions that we use in Victoria. They're pretty straightforward, so I won't go through them too much. But first and last resort we use in Victoria is imprisonment, and pretty straightforward, but just need to remember, if you ask for a definition of imprisonment, it's where people are physically removed from society. They go into a separate space, a separate facility, because they're no longer seen as safe to be a part of the community anymore. So they have to be put in a separate space away from everyone else for usually a set period of time. The next one we have, which I think achieves rehabilitation much more effectively, is a community-based order. So these are for people that are sort of committed in the middle level of crime, so not super serious and not very minor. And it's where you're getting asked to complete a lot of unpaid community work is the really key part here. So the court can order between 50 and 500 hours of community correction. And basically, as part of this community-based order, you take on a lot of things and rehabilitation programs to hopefully change your ways and get you out of the life of crime. And I guess getting handed down a community-based order is a much better outcome than going to prison. It's almost like a second chance to avoid going down that life of crime. And then the last sanction, pretty straightforward as well, is a fine. But what you want to just stress is that it is a monetary penalty that can be handed down, and they can actually hand it down with or without a conviction or without going on your criminal record. And I'll put some things down here that are also really important, that generally they'll also consider your financial circumstances. So they can set up things like payment plans if you're not in the best financial position, for example. And yeah, so moving on to a really good practice question you guys could have a go at doing. So you might like to pause this video and have a crack at this one. So the practice question I've got for you here, what I would recommend is just finding any article, any case study where imprisonment has been handed down. And what you've got here is discuss the extent into which imprisonment achieves the purposes of sanctions. So what you need to look at doing here when you do answer this question is you need to consider both sides. And what I mean by that is, how does imprisonment achieve the purposes of a sanction, and how does it not achieve the purposes of a sanction? So you basically really want to have two kind of paragraphs. One paragraph saying maybe this imprisonment achieves, say for example, protection and deterrence. And then you want to use like a signposting word like however, and say, however, it does not achieve rehabilitation and punish, for example. So I really recommend having a go at this practice question. And just like I've said in previous videos, when you see task words like discuss, it's really important you're considering both sides or strengths and weaknesses and that sort of thing. So I won't talk about this slide here, but feel free to pause and take some notes. What I've done on this slide is I've basically talked about how sanctions or how imprisonment can achieve each of the 5 purposes you need to know, and how it does not achieve the 5 purposes. So you can pause it, maybe take some notes, but like I'll just talk through one of them, for example, that imprisonment is really, really good at achieving protection because offenders are physically removed from society, and they can no longer commit dangerous crimes anymore because they're in a separate space. But one thing to note is that protection might not be achieved is because jail is generally for a set period of time, and if rehab in jail doesn't work, they might reoffend and they go back in and out of prison again, which can be really, really dangerous. So like I said, maybe pause, take some notes on these ones. This is how you would write about how that practice question achieves and doesn't achieve those specific purposes. All right, moving on. So for this next key knowledge point, you need to know the 3 alternative approaches we have to sentencing, but I thought I'd quickly just go over why we do need these approaches in general. So I've mentioned this one a fair few times now, is that a lot of prisoners go back to prison. Secondly, we have the Koori Court because Indigenous Australians make up 25% of our prison population, but only about 2% of our Australian population. So that's really, really a clear issue here we need to address with something like the Koori Court. And lastly, depending on where you go, it can cost on average about $100,000 to keep someone in prison. So we really need to consider that and provide these alternative approaches. So first one we have is the drug court. Now your drug court is primarily for people who are suffering drug addiction and alcohol dependency. So generally speaking, the use of drugs and the use of alcohol is the reason that they commit crimes. And what we have with this drug court is we're trying to rehabilitate offenders. So ideally, we want them to stop their drug and alcohol problems so they can turn away from that life of crime and change it. When you look at the drug court, one really important thing to know is that it is on the same level as the magistrate's court usually. So it's kind of only for minor summary offences. And one really key point to stress is that it is only for non-violent offences. So if a person has been charged with a violent drug-fueled assault, for example, they're not able to access this court at all. It's only for non-violent offences. Secondly, there kind of has to be a bit of a link between the accused offending and their addiction. So what that means is there needs to be a link between their the crime they've done and maybe their use of alcohol on a daily basis. When we move on to the requirements, you're basically undertaking this program with the aim of assisting. So it has the aim of assisting the person to overcoming their drug problem. And they'll have various programs to help them stop that. And as part of it, it might be urine and breath testing to make sure they're on the right path. They do this through like a drug treatment order. So that drug treatment order is basically just outlining how it's going to assist them and ensuring that they put the right steps in place to ensure we address that person's problem. I won't talk about all of these, but each alternative approach to sentencing has its own benefits for the individual and the community. But I guess the main one for all three of them that you can really focus on is that we're trying to assist the cycle or break the cycle of reoffending, I guess. And we don't want them to go into a life of crime. So hopefully by using these programs or using these approaches, we hit it very early. And same for the community. If we have lower rates of reoffending or lower rates of recidivism, saves us a lot of time, a lot of money, and makes the world a much better place. So moving on to the Koori Court. The Koori Court is basically a really informal alternative approach to help First Nations people and basically support their underlying issues to stop their offending behaviours. To utilize the Koori Court, you need to basically say, I'm willing to go through this process, and you have to live within the boundaries of a Koori Court to utilize this system. What's really, really good about the Koori Court is it's treated as like a sentencing conversation. So it's very, very informal. People sit around a round table, and there's an Indigenous Koori elder present, as well as usually the judge or the magistrate. And the whole purpose of having this conversation is to talk about what support services and programs are available to these people, and how can we make sure that we avoid them from entering that life of crime, just like the drug court, for example. So like I said, there's a huge overrepresentation of Indigenous people within our justice system. So we really, really want to address these problems and put lots of funding into programs and approaches like this. So once again, some benefits for individual and community. Might like to pause this and take some notes down on this one to help you remember these. We're going to move on lastly just to our diversion program. Diversion program is primarily for, people who have committed the crime for the very first time. So a lot of first time offenders. And the really, really good thing about using a diversion program is it avoids a person having a criminal record. That's a really essential part. We don't want someone to have a criminal record because it could permanently change their life. So hopefully if we catch them out with a program like this early, we can address those behaviors and hopefully put them on the right path. You can see the eligibility and the requirement just below here. Once again, like the past two programs, they're primarily for your lower level crimes, like your summary offences. And yeah, it's a really, really good opportunity to help, like I said, avoid that person's criminal record. Once again, lower rates of recidivism and ensures more accountability in our community. Okay. So I know I've been talking for quite a while. I've just got one last point to go, which is comparing sentencing practices. So when you are comparing sentencing practices, so this is our last key knowledge area for this topic, we need to make sure that if we see the task word on an assessment task that says compare, we need to make sure we use the words similarities and differences. So if I'm asking you to compare an apple and an orange, I want you to tell me what's the similarities between an apple and orange, and also what are the differences. So I've kind of summarized them for you on the next slide here. And as you can see, when we start off with the similarities, we're very, very similar with Northern Territory, for example. We use those 5 purposes of a sanction that we've talked about in this video today. And we want to really achieve these purposes when we do hand down punishments. We also have pretty much the same or similar sentences handed down. So most commonly in both Northern Territory and Victoria, we'll always hand down imprisonment, fines, and community-based orders. And lastly, both jurisdictions have minimum terms, or like what a minimum sentence is for someone for a number of offences. So an example I can think of is if that you assault a paramedic or a emergency services worker, you're meant to face a 6-month mandatory imprisonment term, for example. When we flip over to the differences, we're a little bit different in the sense that there are much fewer courts in the Northern Territory. They have 2 main courts in the Northern Territory in terms of how they sentence people, whereas Victoria has 3, as you know, Magistrates, County, and Supreme. Next thing we have that's outlined is there are actually much fewer prisons in Victoria and much fewer beds within each prison. So that might be due to funding or a whole range of various factors. And lastly, the Northern Territory does have some sentences that we don't use in Victoria, or we've discontinued in Victoria. So recently, Victoria has stamped out suspended sentences and home detention, but Northern Territory still uses these ones. So a little bit different, but not a huge difference overall. So a bit of a longer video like I mentioned, but just to recap, really important that for this SAC, you remember your task words. So on your questions, when you get given task words, you make sure you answer them correctly. So I'll put an example there as compare, as like the similarities and differences, but just make sure you know things like explain, which is talking about the what, how, and why of a concept, distinguish, which is telling me the difference between a concept, and also a really important one is discuss, so talking about both sides. Make sure you know your 5 purposes of a sanction, so punish, protect, rehabilitate, etc. And make sure you can talk about how in this chosen case study, how might protection be achieved, for example, and how might it not be achieved. And lastly, just remember we have those 3 alternative approaches to sentencing. And the whole reason we have that is we want to address crime and hopefully bring down rates of crime in our community. So hopefully that one helps this video. If you have any questions, feel free to drop a comment below, and I'll see you guys in the next set of summary videos.